Welcome. I'm Professor Nicole Garnett. I know many of you, if not most, and this is an event that is incredibly important to me and really privileged to have us, our friends here today. We let Laura come even though she's not named Michael. Otherwise, you have to be named Michael to be on this panel. A little public service announcement is that if you are interested in parental choice, a couple things. First of all, my husband and I and Ernest Morello recently edited this book of parental choice essays by the great Jack Koons, who has been the foremost advocate and prophet for school choice since the 60s. And many of these essays date to the 70s. It's a wonderful book. Jack is a wonderful man. So there are copies of the book available if anyone would like to read them, to grab one. And at 3:30 p.m. today, and it's available on the Zoom link for this event. On the event, there's a Zoom link. We are honoring Jack and launching his book by Zoom, and with some folks who honor Jack, talk about his work. Jack's now 93 years old. This event means a lot to him, and it's so exciting because this is a very, very exciting time in the history of the parental choice movement, both legally and in terms of policy. So I'm going to introduce our panelists very quickly, and then we'll just have a great conversation. First, Michael Bindas is a senior attorney at the Institute for Justice, where I began my legal career. He leads the educational choice team, defending parental choice programs in courts across the country, which is how I began my legal career, although I was not nearly as important as Michael. He successfully argued Carson versus Makin in the United States Supreme Court, a case that means a lot to me because when I was a baby lawyer at the Institute for Justice, together with a now retired attorney named Dick Comer, we were the first team of lawyers to challenge the program that was at issue in Carson versus Makin, which Michael will tell us about. Michael Bindas is a graduate of West Point and the University of Pennsylvania Law School, and he clerked on the Fifth Circuit for Judge Risa Hawkins Barksdale. Next, Michael Helfand is the Brenden Mann Foundation Professor in Law and Religion and co-directs the Newt-Bar Institute for Law and Religion and Ethics at Pepperdine. He also directs the Pepperdine and Yale Law School Religious Liberty Clinics. He holds JD and PhD from Yale and a BA from Yeshiva University, and he clerked on the Sixth Circuit for Judge Gibbons. Michael Moreland is the University Professor of Law and Religion and the Director of the Eleanor H. McCullen Center for Law, Religion, and Public Policy at Villanova. He graduated from Notre Dame, and then, we don't understand this part, the University of Michigan Law School, and he clerked for Judge Kelly on the 10th Circuit. And finally, my dear friend Laura Wolk Slavis, recently joined Becket after some time practicing law at Kirkland. She graduated from Swarthmore College and Notre Dame Law School, and then clerked for Justice Thomas, as well as Judge Janice Rogers Brown on the DC Circuit and Tom Hardiman on the Third Circuit. So I thought I would just start by asking you, Michael Bindas, if you could tell us a little bit about Carson and also just give us some of the good news. What does school choice look like in the United States today?
Sure. So I'll give you a quick overview of what school choice is. Some of you may not be familiar with the concept, but school choice programs are simply programs that provide financial assistance for parents in order to empower them to choose the schools or forge the education that's best for their kids, to opt out of the public system if it's not working for them and choose something different. And these programs typically fall into three categories. The one y'all might be most familiar with are what are commonly called voucher programs, right? These are just publicly funded scholarships that parents can use to send their children to a private school. They're no different than the GI Bill or the Pell Grant. It's just at a K-12 level as opposed to higher ed. Second type of program is what are called tax credit scholarship programs. They're like vouchers in a sense in that they provide scholarships to kids that they can use to attend a private school. But unlike vouchers, they're not publicly funded. Rather, the state just offers a tax credit for taxpayers in the state to incentivize them to contribute to nonprofit scholarship organizations that in turn award scholarships to kids. So again, like vouchers in that they provide scholarships, but they're merely incentivized with a tax credit rather than publicly funded. And then the most recent kind of innovation in the school choice movement is what are called education savings accounts. These are government authorized savings accounts into which the government will make periodic deposits for parents to use on a wide array of educational services for their kids. They can use them to pay tuition at a private school, but they can also use them for a whole host of other educational services. So virtual learning, homeschool curriculum, special education therapies. It really empowers the parent to customize an education that will best meet the needs of her child. And tax credit programs can be publicly funded like vouchers, or they can also be tax credit incentivized like a tax credit scholarship program. So those are the three types of programs. They're operating now in 31 states, plus the District of Columbia and Puerto Rico. And I think about 700,000 students annually are receiving an education through one of these programs. So providing great opportunity to hundreds of thousands of kids. Historically, these programs were targeted to specific demographics, so maybe children in failing public schools, low-income families, foster children, children with special needs. But the trend, certainly over the last 3 years, has been toward universality. There are now 6 states that have programs that have universal eligibility. Every child in the state is currently, or some of these programs are being phased in over a period of a couple of years, but in the next couple of years, every child in the state will be eligible for these programs. So a quick overview of what the programs look like. When these programs were in their infancy, the big unresolved legal question was whether they comport with the Establishment Clause. The opponents of parental choice, typically the Public School Teachers Union, said because they allow parents to choose religious schools, that somehow constitutes a state establishment of religion. Thankfully, the US Supreme Court rejected that argument in 2002 in Zellman versus Simmons-Harris. Court says, so long as these programs are neutral toward religion, meaning religious and non-religious schools alike can participate, so long as they operate on the private choice of parents, meaning it's parents rather than government who decide what school their kids attend, there's no Establishment Clause problem at all. The opponents of choice, however, are a dogged bunch, and they didn't just pack up and go home after Zellman. They retrained their focus to state constitutions, specifically state Blaine amendments, which I'm guessing many of you are familiar with. These are provisions in state constitutions that prohibit public funding of religious schools. They have a sordid history that I wish we could go into, but we won't have the time for that, but very rooted in 19th century nativist bigotry. And the opponents of choice started weaponizing these provisions and saying, doesn't matter if choice is permissible under the Establishment Clause of the federal Constitution, it's still prohibited by state Blaine amendments. And that became the next big question in school choice litigation. Starting with Trinity Lutheran Church of Columbia versus Comer in 2017, that issue started to become resolved. In that case, as you probably know, the Supreme Court held that Missouri could not rely on its Blaine Amendment to exclude a church-run preschool from a playground resurfacing grant program. Great outcome. You would think that that might have meant that, likewise, a state constitution can't bar parents from choosing religious schools under a school choice program, but there was this little thing called footnote 3 in Trinity Lutheran, I think is the most infamous Supreme Court footnote other than perhaps footnote 4 of Caroline Products. And the court basically says the only thing, or a plurality of the court, enough though such that it was left the question open. The court says the only thing we're really addressing here is whether a school can be, or the church can be excluded because of its religious status, that is, because of its identity. We're not talking about whether the state could condition the grants on the church refraining from particular uses, religious uses with the grant. This is just about excluding based on the religious status. And so the opponents of choice looked at that footnote. They said, school choice programs don't just fund religious schools, they fund religious uses. Namely, kids can put these scholarships to the use of procuring a religious education. And so they continued their attacks under Blaine amendments. And then I'll close out here by saying, in the course of the next few years, Espinoza versus Montana Department of Revenue and Carson versus Makin, the court finally resolves the question of whether a state law, whether it's a Blaine Amendment or statute, can bar a school choice program if it allows parents to put the program to the, quote, use of procuring a religious education. We could talk about Espinoza perhaps, but maybe I'll just go straight to Carson in the interest of time. As Nicole mentioned, it involved a program in Maine, very rural state. Many school districts don't have a public school or don't have a population sufficient to sustain a public school. And in that situation, a school district can do two things. It can either contract with a school in a neighboring town and send the resident children there, or it can provide tuition to children in the town to attend the school of their choice. It could be public, it could be in a neighboring town, it could be private, it could be in-state, it could be out-of-state, it could be out of the country. But the one thing it couldn't be was religious. So you could go to, Miss Porter's, the Taft School. Kids were going to school in Santa Barbara, California, to kind of posh prep schools. But a parent better not dare try to send her child to a Jewish day school in Portland or an Islamic school or the school at their local parish in Augusta. So we challenged that exclusion in the wake of Espinoza, and the court finally resolves this question of whether there's a meaningful distinction between discrimination based on religious status and discrimination based on religious use. And the court said, at the end of the day, these are really two sides of the same coin. The court, citing its earlier decision in Our Lady of Guadalupe, says religious schools are in the business of providing religious education. This is central to their mission. It's part of their identity. Yes, it's what they do, but it's also part of who they are. And to pretend that there's a meaningful distinction between being religious and doing religious stuff is just silly. And then finally, the court says, and if it were otherwise, if we allowed school administrators or state public officials to troll through the curriculum and activities of schools to determine if they are sufficiently irreligious and therefore a permissible choice, or too religious and therefore an impermissible choice, we would be inviting all kinds of entanglement problems that would raise concerns under the Establishment Clause, and we would be possibly leaving an opportunity for government bureaucrats to play favorites with particular denominations over others. And for those reasons, the court said, however the exclusions described, status-based, use-based, it violates the Free Exercise Clause either way. And that led to resolution finally of the big federal constitutional questions surrounding school choice. And as a result, we've seen an explosion of newly adopted legislative programs throughout the state, and I think we're going to have a banner year that we can talk a little bit more about here in a bit.
Yeah, it's an exciting year. So Carson is about school choice. It's interesting, although it has little immediate implications for school choice, because except for Maine and Vermont, no school choice program ever excluded religious schools. But it has huge implications, I think, outside of for religious liberty outside of the parental choice context. And I know Michael, Helfand, and Laura are involved in some of other kinds of Carson related. I mean, Espinoza, Carson, and Trinity Lutheran established this basic non-discrimination principle. If the government chooses to fund a private activity, it cannot choose to exclude religious providers of that activity from the benefit of the program. So I thought maybe we could just talk a little bit, Laura and Michael Helfand, about Carson's implications outside of the parental choice context.
Sure. It's interesting. It's not a direct parental choice necessarily question, but I think it does actually implicate parental choice in some ways. So, I mean, like Michael Bindas was saying, these three cases, Trinity Lutheran, Espinoza, and Carson, they're very close in time. They're all within the span of 5 years. And you would think that, especially after Espinoza, that states would start to realize, okay, some of our programs need to be reformed, or at least there are clear constitutional questions. At least when litigation is filed, we should think seriously about opting to just not enforce this law, or to make a statement that this is no longer how we interpret the law in light of these cases. But that's not what's happening. What you're seeing is a continued attempt to distinguish based on finer and finer lines, the program being challenged in light of the precedent that has existed. And so what we are seeing and what we think is probably going to continue to happen is that states aren't going to be in the business of going through their programs and reforming them in light of Carson and getting rid of these requirements that are no longer constitutional. It is going to lie either on political lobbying or through litigation to continue to make these changes happen. So Becket recently has taken on a case, and we just filed a complaint in a case that I think represents this, because what you'll see is that these Blaine amendments, they are thickly woven into state regulations in so many ways, including ways that you might not necessarily immediately think of. One of those ways we have found is in California state law regarding special education funding. So there is a federal law called the Individuals with Disabilities Education Act. It entitles every school-age child with a disability to a free and appropriate public education. Obviously, public in that acronym implies usually this will happen at a public school. But there are certain instances, just like Maine's program, that the public school either doesn't exist or it is incapable of providing the free and appropriate public education to this child. So what the IDEA says is in those instances, those funds, the money that would be given to provide the child with the free and appropriate public education can be redirected to another educational institution, including private schools. It doesn't say anything, there's no adjective there, no disclaimer. But in California, because of its, no doubt because of its Blaine Amendment, the word non-sectarian appears over and over and over and over again in its education code. And so with respect to this particular special education funding program, it says that in order for funds to be redirected to they call them non-public school, for the child to receive their special education, the non-public school has to be non-sectarian, just like in Carson. So they have to certify to their non-sectarian status, and it's an extremely broad definition of what it means to be sectarian that covers, basically any type of religiously affiliated school. So, once again, we're bringing this case. We are hoping that that California politicians would see the writing on the wall and realize, in light of Carson, in light of Espinoza, this is just a dead letter. It has to be reformed and not enforced. But there is, based on what we've seen in the past, we think that there is a likelihood that instead the state will dig in its heels because there still is this vested interest in bringing these disestablishment theories, no matter what the Supreme Court precedent says. So what we think and what I think is going to end up happening is the chances of success are vastly higher than they used to be. But I do think that we are still going to there's going to be a lot of litigation that needs to occur on the ground because states are not going to be, at least, the greatest offenders are not going to be helpful in our cause by doing any of the work for us.
Well, I should probably start with a thank you. These days, I sometimes call Laura my lawyer. And Becket and the team that Laura's on is representing, I'd say, my faith community. It's my kids' elementary school, one of my kids' high schools, and a couple of my friends. So this is great. So thank you for doing that. One thing that Laura didn't quite emphasize, but maybe it's worth mentioning in terms of the future need for litigation in states. Why is that going to be the case? One of the puzzles in this case, Lofman, out in California, is that my faith community, Orthodox Jewish community in California, has long struggled to have special needs infrastructure, and families of special needs children have typically left the state, go to New York, New Jersey, and Florida. Those are the three big Orthodox Jewish communities where people have gone. And so a school, some folks in my faith community started opening a school in California, or a special needs school. And this whole thing starts because I got a phone call from the special needs school saying, what's the deal with what does sectarian mean? I'm like, oh boy. Where do you want to start? So you can see how this went, right? And of course, my first phone call is always to Becket, and I'm like, can we sort this out? And then Carson comes. One of the issues is, who's going to serve as the plaintiff in a case like this? And this is being recorded, right? Oh well, what the hell? And it's scary if you're a school and you want to open up and you want to provide this kind of service to your faith community. Do you want to be the one who's named in a plaintiff and named in a lawsuit? And then after you win, and oh God, that's where my bet is, that then has to turn around to the government and say, please start referring children to our school. I mean, that's not going to be a great conversation. And so, there's a concern about actually being the first one in to file these lawsuits because of the future impact for your ability to reasonably deal with government officials in the jurisdiction. So the fact that you win in Carson completely and transformatively alters the litigation, the jurisprudential landscape. But then you're going to need all these kind of smaller lawsuits with people who are in the back of their mind are going to be worried about what are the repercussions if they're the ones to file the lawsuits. And then you find yourself, you need to partner with people, you need to bring people in and convince people that this is the just fight. There's no reason that a special needs child should not be able to receive an education simply because of the institution's faith affiliation. So, that's one big piece of this, that it's not just that it's going to require, retraining legislatures through litigation, but it's also going to be about finding people who are willing to do that, given what the potential kind of, if you're thinking about this as a three-dimensional puzzle. Maybe I'll say one more thing or two more things. It's not just going to be a question, at least for my faith community. I used to talk about this topic like I was a lawyer, but these days I find myself doing more and more work with institutions of Orthodox Judaism who are particularly concerned about some of the distinctions in this area, the way in which the court has tried to draw lines. In the pre-Carson days, this idea that you would have discrimination based on status was prohibited. But if your state was just saying, you're simply using the funds for something religious, and that we can exclude, this I would say was a pretty significant worry within my faith community. And I suspect faith communities that are, let's call it deeply conduct-based. Let's do a quick, what does Orthodox Judaism look like? I do tons. I was bringing pizza into the restaurant today, right? We're eating it at Roar's lovely place. I wonder what the food tastes like. And I came in, right? I came in with a box of pizza. I do 1,000 things, I think, thousands of things a day that comport with the rules of my faith. And if the issue was each time I am doing something or using funds, acting in a way that was religious, it meant I could be excluded from some sort of generally available government funding program. This could be really problematic. One area we thought about, we filed an amicus brief making this point in Carson, public-private partnerships when it came to vaccines. This is probably a really good example. It was the view of the client I was representing in Carson, the Union of Orthodox Jewish Congregations of America, that getting a vaccine was a religious obligation. This creates a weird puzzle, because that means each time I take a vaccine, let's say the government's funding it, I'm using it for something religious. Oh God, is this the answer? Imagine you're in a state that says no money can go to anything religious, right? Your typical, garden variety Blaine amendment. So that means the state's obligated to exclude religion from as much as public funding as possible. So now you have a vaccine policy, you have public-private partnership on vaccines. The state is excluded to make sure that they don't fund my vaccine because I think I have a religious obligation to get it. Do you see how the using something for a religious purpose can create? Now, I don't think anybody would actually do that. I mean, you'd have to be out of your freaking mind. Oh God, let's save a whole bunch of people. Wait, I think he thinks he has a religious obligation. This is a terrible idea. I hope everybody realizes that. But then what's the status use distinction supposed to mean in this context? Sometimes I would say this and people would respond saying, no, not that kind of religious use. That's like a secular use. I'm like, how exactly are you tagging things?
Kind of religious.
Yeah, exactly. It's the one that comports with what I think you should be doing. No, that doesn't work. What about my kosher pizza? So the point, this was, I would say, almost a distinction that was borderline offensive to my faith community because of the way in which it seemed to privilege a certain vision of religion, like the way in which you do religious stuff. And it's about affiliation and status as opposed to like the day in, day out things that people in my community do. And the way in which the constitutional doctrine was being built was like discrimination against, I don't know, people like that, that's going to be fine. But like this other type of discrimination, that's what we're excluding. And so Carson v. Makin, that way, the stakes were pretty big for us. And the kind of getting rid of that status use distinction was particularly important. And what does that mean going forward? So, you have the case that Laura and the team at Becket are working on. I suspect I work at part of two religious liberty clinics. We have one at Pepperdine. I teach at Yale in the spring. We have a free exercise clinic there. One of the things that we're really starting to think about is all these state laws, even outside of education. Mm-hmm. I mean, you still have historic preservation grants that are excluded from religious institutions in New Jersey, and you still have a universal pre-K program in New York where you can get funding except for the hours that you're doing religious instruction because you're using it for something religious. In all these states and all these jurisdictions, you have this exclusion woven into the fabric of the law. And you're going to have a challenge in terms of finding plaintiffs because they're going to have to then turn around for the funding to partner with government. And the question is going to be, finding people of great commitment who are willing to put themselves out there and then trying to re-educate, I would say, local state politicians about what the Constitution does and doesn't allow going forward.
I think that's a great point. I mean, the New York's universal pre-K program allows you to be religious and receive the money, but you can't, not for religious stuff. So there's actually an exception that says you can talk about religious figures, but only historically. So you could tell the preschoolers, Noah built a boat, but we can't tell you why.
Well, there's a great example. I forget who made this in one of the amicus briefs in Carson. Is like you can teach kids 2 by 2, but if you use Noah's Ark as an example of doing then so.
So the New York pre-K program also, we learned you can have religious words on your shirt, like uniforms, if it's in your name, but no religious symbols. And so, but to Michael's point, Michael Helfand's point, the Archdiocese of New York participates in that program to the tune of millions of dollars a year, and they've accepted these requirements. It's not like they really are going to turn around and want to sue. And so I do think these are a lot of, this word sectarian is just, it is a dirty word for someone else's religion. It is code bigoted. It's throughout all of education law and other kinds of laws. So it's really important. Well, go ahead.
So I was just gonna say the other thing too, to in terms of like the plaintiff point, I think that is really important is like religious institutions are under attack from so many different angles that it's not even like in terms of like finding a plaintiff. It's like so many of these religious organizations are under assault from. They're also playing defense. So it's like you have to consider that the stakes aren't just high for them because of this one particular issue. It's like they have all these other balls that they're juggling, and it's like, is this a thing? Is this, can we risk somebody turning around and yanking this funding because we're arguing that we should be able to do these things, and then you might get a really angry response that says, well, in the interim, we're going to launch a counterattack and say we're not giving you any of this funding.
I think in the school choice cases specifically, it's a little bit easier to find those plaintiffs because no one was going to tell Dave and Amy Carson what was the right education for their daughter. They knew what it was, and they were willing to do whatever they needed to ensure they could get that education, that other kids could get that education as well. But that's a much different thing than the institutions having to kind of coexist with, and be regulated by the state, and that's a very difficult line to balance.
So that's actually a great pivot to the next thing I wanted to talk about. So after the victory in Carson, and it sounds like the late Chief Justice Rehnquist once said to my husband, patience and perseverance made a bishop of his reverence. And the story of Carson is a story of perseverance because when we first challenged it at IJ, it was in 1996, and the victory came in 2022. It was, and in between probably 8 lawsuits. I mean, so many efforts. And so I do think like this is going to be a war of attrition against the state. Carson took, it was, when I picked up Johnny at swim lessons the day that it was decided, and I'm sobbing, and he was like, "What's the matter?" I'm like, "It's been a long time coming." But I think there's just going to be, for those of you who are really interested in fighting this fight, remember, like, just don't give up. it's going to take a long time sometimes to get to the right answer. And then, as Laura points out, then they can still mess with you, which is what happened immediately after Carson. Immediately after Carson, the state said, oh, yeah, by the way, you have to comply with these non-discrimination requirements that require you not to discriminate on the basis of LGBTQ status and admissions and hiring, leading many, including Catholic schools, just to say, okay, we're not participating then. So I'd like to ask about the regulatory strings question. You probably know this, but yesterday or the day before, the First Liberty and Convoy filed a lawsuit on behalf of a Protestant school in Maine challenging these non-discrimination requirements as a free exercise violation. So far, parental choice programs, the regulations have been light touch, and they haven't really threatened out of religious liberty, core religious liberty principles. But I think we would be foolish to think that the regulations aren't coming. By the way, they can regulate you even if you don't take the money. I talk to bishops sometimes, and they're like, I don't want to take the money because then they can regulate you. I'm like, well, they can regulate you either way. So I do think that this next question is going to be about unconstitutional conditions. It's going to be about regulation of schools. And I wondered if any of you had any thoughts about that, or maybe even in particular, the thoughts about this claim that the Maine school is now making, that requiring them to succumb to these regulations they say violate their deeply held faith commitments is a free exercise violation.
Maybe I'll just pick up on that point about where we're going, but I do want to underscore something that Nicole said about where we've been and how remarkable it is if you think about the change from, say, the 1970s. I was on a podcast for the National Constitution Center with Erwin Chemerinsky, the dean at Berkeley, about Carson and Coach Kennedy, different issue. And Dean Chemerinsky said this was a revolutionary breaking of the wall of separation of church and state. This is a transformation in the doctrine of constitutional law. And I think it's worth saying that the perseverance here was on the part of those who said that, no, actually the error was begot by, in some ways, Everson way back in 1947, but certainly cases like Lemon and Nyquist from the 1970s that had this hyperactive doctrine of separation of church and state that was ahistorical, not part of the original understanding of the Establishment Clause, and that along the way there were efforts to kind of chip away at that use of the Establishment Clause as a kind of permission for that separationism in cases like, in the free speech context, Rosenberger versus Virginia, or the equal access cases like Lamb's Chapel, where no, if you provide benefits, if you're providing benefits with regard to, in a public forum, you're providing benefits with regard to access to schools, you can't then, as the government, use the Establishment Clause as the basis then for discriminating against religion. And the way in which I think people doggedly for 40 or 50 years chipped away at that, culminating in the success here. But Nicole,
60.
Yeah, 60, right? Professor Garnett is right. I do think that so that's where we've been. I think the next question is where will we go from here? And we actually had a symposium on this very issue. I think the articles are amid editing right now. Michael Helfand was at it as well last fall, about this question of unconstitutional conditions in the free exercise context. That is to say, what kinds of conditions can the government put on grants, or still by way of direct regulation, as Professor Garnett says, but in particular, if they have if the government has some kind of benefit program of one form or another, what kinds of conditions with regard to hiring and admissions can it place on them? And in that way, there's a very big question, as we talked about at that symposium. There's a large development of doctrine with regard to unconstitutional conditions in areas like free speech, for example, like the USAID case, and Russ versus Sullivan, for example, but much less in the free exercise context. And so what kinds of strings can the government put on it? Is there a germaneness requirement for the condition with respect to the government's objectives like we have developed in the speech context? Can that be transported over into the free exercise context? I think that's an open question. And then I know one thing that we had talked about in our run-up to this is, what about the ministerial exception, which, at least with regard to the hiring and management of employees for those who perform substantial religious functions, including, as Our Lady of Guadalupe and Hosanna Tabor say, that doesn't just mean ordained clergy, it means those who perform functions within the educational institution that affect the religious atmosphere of the institution, which in many contexts is virtually everyone. that there's a constitutional protection there, and to what extent will the state be able to interfere with that protection if it, for instance, imposes anti-discrimination requirements. I think that given the strength right now of the ministerial exception doctrine developed in the lower courts over many years, but especially in the Supreme Court with Our Lady of Guadalupe and Hosanna Tabor, I think the institutions are on pretty firm ground with regard to being able to evade maybe some of the worst of anti-discrimination rules in that area. But with regard to admissions, I think it's a different issue, potentially.
So we actually, in Loffman, we did bring an unconstitutional conditions claim. I definitely think this is going to become a really important area, largely for what Professor Moreland was saying. You know, it is much more developed in free speech and property cases, takings cases. But if you read free exercise cases like Sherbert, and even in Trinity, I think it's Trinity Lutheran, where the Chief Justice says something like, they could either continue being a church or they could get this grant. Like that is unconstitutional conditions. Like that is the whole point of the doctrine. So like you read these cases and they don't call it unconstitutional conditions. The whole idea that you can't coerce or pressure or impose a penalty on someone for the free exercise of their religion, that is what, you know, the unconstitutional conditions doctrine is getting at. So, you know, there are these open questions, but I do think that that this is going to become a really important area, and like pointing courts and people to the areas of these cases that actually are concerned with these types of strings. And to your point about the ministerial exception, I think it is definitely true that the ministerial exception is the most developed. You know, you have these two very on-point Supreme Court cases, but that the Supreme Court has also made clear that the ministerial exception is just one part of what church autonomy is. And church autonomy affects not just employment relationships, but it affects all management governance decisions that implicate religious organizations' doctrine. And so again, like I know we're specifically focusing on school choice here, but I think really building up this other area of church autonomy, saying, we're a school. Our whole job is to pass on the faith to the next generation. How can we possibly do that if we have to hire or admit or teach, you know, et cetera, things that directly contradict and undermine that message? Like that is covered by church autonomy. But so far, the focus has really been on the ministerial exception. And I'm hopeful that now that that doctrine, you know, it's unquestionably present, you can't, you know, not acknowledge its existence anymore, that there will be more work done on the broader sphere of church autonomy that would protect a lot of this stuff and get rid of a lot of these regulatory strings.
So Michael Helfand, on that last one, I actually have been thinking about this in the Jewish day school context. So Catholic schools admit non-Catholics and even non-Christians. I think then in that question, the Catholic school context, the admissions criteria, it's really about discipline policy, like, right, but who you expel. But in the Jewish day school context, especially in the Orthodox Jewish day school context, I understand that the policy is not to admit non-Jews and not to hire non-Jews except for secular subjects, right? So there's the bifurcation of the, anyway, maybe I'm wrong about the second. But so is there a case to be made if you're a Jewish day school to the courts? Look, if you make us admit non-Jews, we're not a Jewish school anymore. We don't do this for a reason. I'm really just musing here because it's something I've been thinking about.
I think the problem is I have unconventional views about the unconstitutional conditions doctrine. I think that Michael M. may remember this from our, everyone got up there and was talking about the unconstitutional conditions doctrine. The title of my paper was, there are no unconstitutional conditions on free exercise. So that was a thing.
All right, just play doctor then.
Let me try and see. So I may look back to Nicole's question at the end to apply this, but you know, here's the puzzle to me. To have an unconstitutional condition, you need something unconstitutional. Everybody with me on that? I mean, I think that's the brand. So now we still live under a Smith regime, so laws that are neutral and generally applicable, whatever that might mean, changes a lot, those aren't unconstitutional. So if a state puts a condition on funding that just is neutral and generally applicable, you may have a condition problem, but I don't see how you have an unconstitutional condition problem because it's neutral and generally applicable, meaning they could both tie funding to that. They could also just impose that. That's kind of, Nicole, to your point about, it doesn't matter if you take the money or not. So the generic, anti-discrimination laws that would apply to getting funding, assuming they have no exceptions, which, did I hear a laugh? Because that never happens. Okay, I get it, I'm with you. Indulge is crazy hypothetical. Assuming they have no exception, I don't think those are unconstitutional. I think those are all fair game, both in terms of tying funding to them and in terms of also potentially regulating in and of itself. Let's leave Laura's comment aside. I need to think more deeply about the church autonomy point. So maybe I'll say something about that in a second. And when I say think more deeply, I mean within the next 60 seconds. I'm going to figure out what I think. So I think if you really want to get at the unconstitutional conditions doctrine, or at least use it for real in order to combat strings, what you need is a return to the Sherbert regime, where you have a substantial burden rule. There, whether you're using the Sherbert rule or unconstitutional conditions rule or a Sherbert and unconstitutional conditions rule, those are interesting, but not for now. Certainly they would constitute substantial burdens on religious institutions if you had a Sherbert regime. So Sherbert pre-Smith, the idea was anytime you substantially burden religious exercise, government has to satisfy strict scrutiny. So if you said you have to abide by anti-discrimination norms in order to get this funding, I think you just have a classic Sherbert case, and that would be unconstitutional. And this, to me, strikes me as one of the costs of Fulton, the fact that we didn't get a reversal of Smith. So it's not obvious to me that the unconstitutional conditions doctrine is generally going to win the day. Now this, Laura this is why Laura's point is so important. Laura's point is forget all this stuff. This is a church autonomy question, ministerial exception. Yeah, let's think about that for a second. I do think if a state then said, we've got this rule, anti-discrimination norm. In theory, if they don't say anything else, the ministerial exception, I assume, would still provide protection like it would from any other law. Yes, we have to abide by anti-discrimination law, but the First Amendment says ministerial exception provides protection. If a state then went out of its way to try to add language to say, P.S., we also want to say that the ministerial exception can't apply to you if you want to get funding, now I think you start having a neutrality problem. Because however you draft that, either it wouldn't be clear and it wouldn't help the state, or it would be clear and then you have a neutrality problem. I hope that just made sense. So that's how I see an attempt to shield or to eliminate the ministerial exception might go. Now, what about the broader church autonomy question? I mean, this is a tough one. The church autonomy doctrine has not, I think what I'm saying is true. You'd be hard-pressed to identify case law where the church autonomy doctrine has provided this kind of broad protection. I mean, think about Bob Jones for a second. If there were a church autonomy claim, Bob Jones would have gone the other way. So let me put it this way. If the church autonomy doctrine, the idea that religious institutions ought to be protected in making their own decisions, that it also ought to protect them from these types of conditions, there's work to be done. Because I would say the state of play with the doctrine that we have, with cases that haven't been overruled, probably don't point in that direction. And maybe that's where this is all going to go. I mean, that would be super interesting. I don't think that's where we are now. And this brings me back to kind of Nicole's question, which is, so it's certainly the case. Orthodox Jewish Day School is only going to admit Jewish students. That's part of its brand. Also, you'd find spending half the day on Bible and Talmud study plus prayers 3 times a day super annoying if you weren't Jewish. But and I'm told kosher pizza isn't as good as other kinds of pizza. I still have no idea. So what might happen there? I mean, if there were a condition put on funding, I think it would go the same way I just described. Now, if you try to directly regulate who could become a member, i.e. a student, in a Jewish day school or in a religious school, there I think you're on way firmer grounds when it comes to church autonomy. That strikes me as hitting the heart of church autonomy, and I say the state of play probably is that kind of restriction couldn't work.
Do you see in distinguishing between an institutional aid program and an individual aid program that operates on private choice, do you see the fact of the the kind of intermediating choice of the aid recipient as factoring into that analysis? Is it more akin to the latter situation that you described, where with or without aid to the institution, the government just comes in and says you have to start admitting these folks, or you can't discriminate against these, or do you just not see? I mean, if I guess the question is, if private choice breaks the link between government and state for purposes of the Establishment Clause, does that bear on this question of
Who you could admit?
the government's ability to dictate as a condition of participation in a school choice program, where the Supreme Court has said, this is not aid to schools, it is aid to children?
Yeah, but again, and you're envisioning a circumstance, the state says, here's your aid, here's where you can use it. You have to use it in a place that complies with anti-discrimination norms. Is that the idea?
That's the idea. And so the
Yeah.
question is, does that intermediating choice of the parent kind of defeat the government's ability to impose that condition?
I mean, from the government's perspective, they'd just be rolling out a program that has it in it. So they don't need state, it's just what their program looks like. The question then is is the government, I think you want it to run the other way, is the government still sufficiently involved in the choices schools are making such that the free exercise clause or church autonomy ought to trigger some sort of protection? And I think it would work the same way. That's my gut instinct. I haven't thought about it, but as I sit here right now, my instinct is that it ought to work the same way. I could be convinced otherwise probably, but just to be clear, when I presented this paper in the fall, somebody asked, I think it was Sharif, asked Michael M over here, well, what about what Michael H said? Don't you think that might be right? Michael M said something along the lines of, well, if that's right, then my paper's wrong, so that can't be right.
Right, and
I think that's where we're at, right?
Right.
Right,
and a lot depends, and again, it's all coming in the Notre Dame Law Review online. A lot depends on how seriously you take a kind of anti-leveraging concern in the context of unconstitutional conditions. That it's one thing for the government to just directly regulate and sort of take the political heat for that. And we might have political process concerns with the government doing an end run by using its leveraging power of giving funding as a way of conditioning recipients. Now, how much that can be cashed out in actual legal doctrine, I think there's that is part of what the germaneness requirement in the free speech context is trying to get at. That we're worried that the government will kind of manipulate the message of groups by conditioning their receipt on taking particular messages. But again, how that could cash out in the free exercise context, I think is very much an open question.
So I have lots of questions, including about religious charter schools, but I'm going to put those to the side. You talk to me about that later. I want to have time for questions. I want to just ask one kind of orthogonal question, but I think it's something that's really in the courts now, a lot of talk about it, and that is the sort of side fights that are going on about parents' rights in public schools, objections to curricula, and so this is not something, it's not a school choice issue. It's about the rights of First Amendment, free exercise rights, free speech rights of parents to object within the public school system. Now, if you've taken education law from me, and many of you have, you will know that I don't think these claims are going anywhere. But I'm curious if you all think there's anything to these parents' rights claims, and where leverage about parents' rights outside of the parental choice context, or maybe even within it in some contexts, might work.
Well, I hesitate to say this on a panel with three people who are very involved in constitutional litigation in one form or another, in a clinical or other form. I think I'm on the same page with Professor Garnett here. So we're talking about Meyer and Pierce, the 1920s substantive due process cases that held that parents have a 14th Amendment right to direct the education upbringing of their children, which have now been 100 years old, and the question of whether they can be a vehicle then for parents to bring claims when they object to one provision or another of what the, say what a local public school is doing. And my concern, I'll just flag it as a concern, we'll see what happens, is that courts will be wary of, so in Meyer and Pierce, of course, they were kind of very draconian prohibitions on non-public schooling, on foreign language instruction, where the court agreed with the objectors. In one case, a teacher, the other, the sisters who ran the school and the parents. It would be another thing for courts to micromanage curriculum and choices that school boards and administrators were making under the guise of Pierce and Meyer, which is all the more reason why it's important, and we've seen this side of it a lot the last few years, why parents get involved politically, right, in the election of school board members, in holding school boards accountable, who's actually running for school board. I have to say, when my kids attend a public school in suburban Philadelphia where we live, when I first moved there, I couldn't have named a member of the school board if I had to, and now I know every one of them, right? Because of the issues that have come up around COVID closures and policies and so forth. But I think that's the more likely route of the rhetorical traction of parental rights, more so than constitutional adjudication, but maybe someone else here feels differently.
We're currently litigating a case in Alaska that kind of touches on where it doesn't just touch on Pierce Meyer, directly implicates it. So Alaska has it's kind of a school choice program. It's unconventional. It's a public correspondence program that provides an allotment to kids. The kids can use it currently on a whole host of private educational expenses. So it effectively is like an education savings account program. Alaska's constitution has what I call a public-private blame. It prohibits public funding of any private school. So it doesn't have to be religious or sectarian. It's just a complete prohibition on funding of flowing to private schools. This program has been challenged under that public-private blame, claiming that insofar as kids can use these allotment funds to, on purchasing, curriculum from private providers, paying tuition at private schools, it runs afoul of this public-private blame. We are representing a group of parents. We've intervened in the case to defend the program alongside the state. And one of the defenses we're saying is that to interpret this public-private blame, as the plaintiffs are urging the court, is essentially to condition the availability of public benefits on the surrender of your rights under Pierce and Meyer to choose a private school for your child, right? Just in the same way that Maine could not condition the availability of the tuitioning funds on a parent's surrender of her right to choose a specifically religious school, so too may Alaska not condition the availability of these allotment funds on the surrender of your right to choose a private school under Pierce and Meyer. And after all, one of the private schools that was a plaintiff in Pierce was a non-religious private school. So I think that's one context where perhaps I hope we will get some traction in kind of revitalizing the Pierce-Meyer line of cases.
Well, thanks so much. I think we have time for a few questions. Any questions?
In states like Texas, where the AG just gave comment on the school choice policy, what are the steps that Texas needs to take next to move forward on that? For other states that are struggling to wait on it.
So the Attorney General of Texas issued a letter last week, not only saying that school choice would be constitutional in Texas, but that it would be unconstitutional to apply the Blaine Amendment to block school choice in Texas. It was a great letter, very exciting. The next question, it's a political question. I mean, they're debating a $10,000 a kid universal ESA as we speak, and it's coming down to 20 rural Republican legislatures. So the step is get those people to vote for it. I don't think there's much else. There's not a lot else to do.
Right, yeah. And the bill made it out of the Senate Education Committee yesterday. It's going presumably to the floor of the Senate later this week, go over to the House, and it remains to be seen. But I mean, that AG letter in Texas is similar to several now that have been issued in the wake of Carson, kind of opining on these. And I think the problem is a lot of legislators don't necessarily understand the interaction of the federal Constitution, the state Blaine Amendment, the Supremacy Clause. Like there's a lot going on there that the average legislature just doesn't fully appreciate. So I think these AG letters have been helpful. They're certainly not necessary. Applying a Blaine to block a program is unconstitutional, AG opinion or not, but I think these are helpful in terms of educating legislators that even though they have this provision in the state constitution that they've been told for decades prohibits any kind of school choice, you don't have to worry about that anymore.
And it comes up, I know I was talking to a friend of mine who's doing some work in Idaho where they're trying to get a small ESA, and the people in the education committee are like, no, we can't do it because of the Blaine. Yep. And it's just not true, but legislatively, I think it's still a boogeyman.
Oh, yeah. Do Myron Pearson impose limits? Thanks. Do Myron Pearson impose limits on state regulation of private school curricula, and especially, just first pass and then, the kinds of conditions? I'm thinking especially for Michael H. There's been a lot of talk about stuff in New York City with, and yeah, I don't know if you have any thoughts on that. Thanks.
Is there something going on in New York City? That's weird. Haven't heard about it. Oh boy. Does anybody not know what's going on? Okay, I actually don't want to do that. So let me try to do the thumbnail sketch of what's going on in New York City. So New York, for over 100 years, has had a rule on the books, Education Law Section 3204, for those keeping score at home, that the education, we need to be precise about this. Every child is obligated to receive, and I'm intentionally making this reversing the subject in the sentence. Every child must receive a substantially equivalent education, meaning substantially equivalent in private schools to what they would receive in public schools. Okay, let's leave that aside. So, and over the years, New York education law has added lots of things to what they think is part of substantial equivalency. It has really interesting stuff like math, English, history, science. That has other stuff like, I don't know, arson prevention. I don't know what that is. They have a separate thing for fire prevention. This is arson, I don't know. I don't know. Whatever. You also need to know.
A lot of young boys need to be taught arson. So.
Yeah, nobody's going to be against arson prevention. It's just but that's weird. And there are other strange things there. You have to teach the provision and impact of New York City's state constitutional provisions, which sounds great. Had you asked me as a 10th grader what's in the New York State Constitution, I would have said, what's the New York State Constitution? Do you know? Okay, fine. There are other things in there, interesting things like civics education, and that one provision of the New York education law says that requires, as part of being substantially equivalent, that you provide every child with an education that includes slavery, the Holocaust, and the Irish potato famine. Those are important. Those aren't, there is nobody who's going to be against any of the, I shouldn't say nobody. I think it would be weird to be against any of those three. It's also a funky list, right? Now, if you try to figure out why you have that list, I think you can probably figure it out if you think about the politics of New York State, why you might have that list. Now, what does that tell you? That tells you that the way in which curricula, when created by a legislature, how it forms, right? It forms around interest groups, right? And political willpower. And then you start asking yourself, you say, oh, that sounds great, because that's a pretty decent list, but it's a little funky. And then you're like, wait a minute, I don't know if I want that to be the way that we make the list of what's required legally. Maybe we want, I don't know, call me crazy, educators to try to figure out what children need in these kinds of contexts, or maybe even parents. So this is all what you have in the background. And then you have on the flip side, there have been exposés in the New York Times, you may have read them, about a certain subset of Orthodox schools, Hasidic schools, that are allegedly not providing what we call substantially equivalent education. And New York State Education Department recently enacted regulations that would allow them to do a variety of things, including closing a school that fails to provide a substantially equivalent education. A lot of Jewish institutions filed suit. They even got me to file an amicus brief in the case, which that camera looms so freaking large. They even got, okay, period. That's the end of that sentence. And they've said that this violates a whole host of constitutional provisions, including the Pierce-Meyer line of substantive due process, parental rights, control the upbringing of a child. We just got a decision last week, and the court said, forget about all that constitutional stuff. The New York State rule, the Education Department's rule that says that you can close a private school if they fail to provide this education, that goes beyond what the state is authorized by the statute to do. Why? Because the statute, if you read it carefully, says that the parent is obligated to provide a substantially equivalent education. So if the school fails to do it, then you have to go call up the parent. By the way, how are you supplementing this education? And maybe they're supplementing it with lots of good stuff. Maybe they're supplementing it with nothing. So you can't close the school. You just have to check with the parent. Now, this makes the entire regulatory framework unworkable. think about how many people New York State would have to hire to then go, like, the school's a problem, it's got 2,000 kids in it. Okay, everybody, let's scatter. Everybody interview each set of parents and figure out what the deal is, what they're doing at home. This makes it completely unworkable. So what's gonna happen at this point? Very unclear. You know, I take the question to be like, oh, that's interesting, but what about the constitutional piece? So the brief I filed says something like this. The state has an obligation and authority to impose certain education requirements to the extent that they do what education is supposed to do. I take Brown v. Board of Education, Gratz-Gruder, other cases to say there are two things. One is that provide an education to ensure students can be economically self-sufficient, and also that they can be civically engaged. Things that go beyond that, even if we really, really, really like them, those go too far, and you have to have, 14th Amendment requires the least intrusive kind of educational requirements in order to advance those compelling government interests. So if you ask me, do I think arson prevention, I like it. I have no problem, my kid, it's great. I don't want him burning down buildings, and I'd like him to think about how he could prevent it. That's good. Do I think the state could close down a school in order, if it fails to do that? Probably not.
Maybe one more question. Yeah. Oh, so Will in the back. Right. How about you both ask your questions, Katie and Will, and then everybody will wrap it up together. So.
So you said you weren't going to ask about charter schools, but I kind of want to ask about it. So yeah, potentially Carson opens the door to religiously affiliated charter schools, and I'm just kind of wondering about the discussion of unconstitutional conditions and ministerial exemption, how that would work out if that becomes a reality. Specifically, I'm thinking about kind of like a related context in Johnson amendments where religious groups have given up their right to engage in political speech for the sake of preserving tax-exempt status. So yeah, how would that cash out?
I think my question is related. So in Carson, the court left intact at least some of Locke v. Davie and cited the important and substantial state interest in not using church funds, taxpayer funds to support church leaders. Do you think that part of Carson will be a problem for religious schools to hold out so many of their employees as ministers for purposes of the ministerial exception? And if not, what do you think is left of Locke after Carson?
So I guess I should answer the charter school question because it's sort of my life. It's possible, if not probable, that the state of Oklahoma will authorize the St. Isidore of Sevilla virtual Catholic school in the next month, if they can find enough members to come to the meeting. But yeah, your question. So I think that, I've built my brand on making charter schools not state actors, and in almost all states, I think they should be able to be religious, and Carson compels the state to let them. Two points about that, and then the first is, it's really important to keep in mind that a state can say no to a charter school for all reasons, but the fact that they're religious, and charter schools are not the darling they used to be, and states are by and large not authorizing very many of them, even red states. So I don't really think it's going to be like thousands of religious charter schools anytime soon. There might be a couple in Oklahoma, maybe one or two in Texas. On your point about unconstitutional conditions, though, I do think if they're private, it's the same questions that we were talking about. It's just a different method of funding private schools. Some of those conditions religious organizations won't like, and they shouldn't, but they're not unconstitutional. So it's sort of up to them. If they don't like open records laws, don't be a charter school. So I think, again, there's like a difference here, a prudential judgment about whether it's a good idea to go down this road as a charter school, leaving aside the legal fights, even if you could do it. There's just prudential questions. And then there are religious liberty questions. And a lot of the prudential questions are just, maybe it's not worth the money, or maybe it is. And that's, as far as I can say, seems to me that religious organizations have the same right to make those prudential judgments as anybody else. And the Locke v. Davie question, Katie, is great, and I'm going to leave it to others.
Thanks to Chief Justice Rehnquist taking the opinion for himself in Locke versus Davie, and now his former clerk writing these decisions, like in Carson. Locke v. Davie, I would say, others might have different views, so I said before about the kind of defensive state prophylactic use, if you will, the Establishment Clause. All that's left of that now is state funding of clergy training. because of the way in which the Chief Justice and Carson and others framed what the legacy of Locke v. Davey is.
I think your question, though, was so to the extent that religious schools push the definition of minister for purposes of the ministerial exception, does that in turn expand the application of Locke, given that the state does still have a historic and substantial interest in not funding the training of ministers?
But I would say clergy, right? I mean,
Clergy, yeah. So that's a big thing. Is that the
yeah,
ministerial exception
true.
is very broad.
Yeah.
Where and law the cases, the 3 recent cases make clear it's clergy only. And I do think that, you know, if there was some high school seminary out there that existed still and they, I mean, who knows? And there was like a Carson type question about them wanting to receive publicly available funding, and it was a seminary. Who's to say what the Supreme Court would do if they were directly confronted? Not Locke as a, you know, this is a vague way that we can try to justify what we're doing, but like confronted head on. I really don't know that Locke would survive.
And that it was one of the questions I got from the chief during argument in Carson is, what do we do about Locke? Like, and so obviously we would have preferred that the court overrule it, but short of that, I think Professor Moreland's right. Like, short of saying, I told some students last night, short of saying this decision is limited only to folks named Gary Locke and Joshua Davey, I don't know that they could have done anything more than to relegate it to just that particular scenario.
I don't want to use the word optimistic, but I'm going to use it. I'm far less optimistic than everybody else. I think it's a great question. And if I had to place a bet, like right now, as litigation goes forward, let's say over the next 2 years, I'm willing to bet that some lower federal courts make that move. And I wonder if it will come to a head before the Supreme Court, because it might be somewhat, I don't know. So I think we may live in an environment that there will be numerous jurisdictions that do that and are successful in doing that until, it boils over. Because I think it's right. I think it's a clever argument. I think Locke is still on the books, unfortunately. A terrible decision. It's like internally incoherent. Read some of the footnotes. I mean, it's just nonsense. But it's there and it's real. And your argument would allow a court to give meaning to what otherwise looks like a fake distinction. And I think that's attractive in that way because it gives meaning to existing doctrine and case law that's on the books. So I bet, and I wonder if anybody disagrees with this, I bet within the next 2 years we see a court making that argument.
I think that's probably, I guess one thing, I think that's definitely right, because I mean, they were making, it was pretty clear before Carson that Locke was very narrow and people were still making that argument anyway. But I do think the other thing that has happened since then is Kennedy, which overruled Lemon. So I think Locke, it's not just Carson it's also that any argument for Locke going forward is going to have to contend with, well, Locke was, how much of that was rooted in the Lemon test, and how much of it is justifiable outside of that reasoning. So you're not just going to be contending with the holding of the case and how narrow it should be, but also the reasoning that led to the holding.
I think it's also important to recognize that the ministerial exception, right, is courts applying the doctrine to protect religious institutions, whereas a religious exclusion, whether it was what Maine was doing, what Washington was doing with the Promise Scholarship Program, is bureaucrats imposing a prohibition that harms religion. I don't know if there's a kind of constitutionally meaningful distinction between those two things, but I certainly see a difference, in what's going on in the ministerial exception case as opposed to what Washington bureaucrats were doing in Locke versus Davey.
So 3 things. First, get your book. Second, everybody should get to spend an hour with Jack Coons at some point in their life. And today is your opportunity at 3:30 by Zoom. I promise you won't be disappointed. He's promised to sing. He has composed a song about parental choice for the occasion. And he sang it to me, and it's pretty good. And finally, this has been a fabulous conversation. I've been looking forward to this event all year, so let's thank everybody.
Thank you.